Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. I very rarely do DC Circuit cases, and won't be doing one now. But I must note that this week, the DC Circuit appears to have largely agreed with the 7th Circuit decision in Bridkavi v. Mayorkas from last month to hold that after Patel, district courts, quote, lack jurisdiction to review a non-citizen's claims that USCIS violated the APA in denying an application for adjustment of status, end quote. Even though the denial was not based in any finding of discretion. And really, the DC Circuit rejected two of the best arguments to avoid Patel being put forth by non-citizens' counsels at the moment. The circuits are falling. The circuits are falling. That being said, we've got a really interesting batch of cases this week, with some serious non-citizen good. Starting off with the most appropriately named podcast decision since Islam v. DHS. First case, Kong v. United States, published by the First Circuit on March 15, 2023. This is a very complicated case about challenges to immigration detention. Hang in there. It's worth it. Mr. Kong is from Cambodia. He came here as a refugee in 1982 at 9 years old, very shortly after Vietnam kicked out the genocidal Khmer Rouge regime that had killed about a third of Cambodia's population in the mid to late 1970s, following the Nixon administration's illegal bombing campaign of Laos and Cambodia in connection with the Vietnam War. That is the world Mr. Kong was born into and raised in, and then somehow unexplained, he made it to the United States. 13 years later, at 21 years old in 1995, Mr. Kong was convicted of aggravated assault with a weapon, receiving a 2-year prison sentence. He was eventually placed in deportation proceedings, and he received the final order of deportation to Cambodia in 1996. But at the time, the U.S. government did not have a repatriation agreement with Cambodia. In fact, if I'm not mistaken, the U.S. government refused to even recognize the post-1979 government of Cambodia, and I believe into the Clinton administration continued to recognize the ousted Khmer Rouge people like Pol Pot, because the Khmer Rouge had been kicked out of power by a Vietnam invasion, and the U.S. opposed Vietnam. Strange bedfellows indeed. If you can't tell, I care deeply about Cambodia, having spent some time there before law school. There are quite a few individuals like Mr. Kong in the United States, child refugees from Southeast Asia who fled the 1970 and 1980s wars, got criminal convictions as young adults, got deportation orders that weren't ever executed because we didn't have relations with those countries, and who now are in their 50s and have completely changed their lives. But they still have those old convictions, and they still have those old deportation orders. And in recent years, the U.S. has reached repatriation agreements with Cambodia and Vietnam. So people like Mr. Kong are potentially in big trouble. Quote, In the 18 years following his release in 2000, Mr. Kong avoided further criminal convictions, married a United States citizen, raised 3 children, and maintained steady employment, end quote. He also appears to have showed up to all his ICE deferred action supervised release appointments, until his last ICE appointment in 2018. I mean, he complied with that too, it was just his last. Mr. Kong may have had his suspicion, maybe. After all, shortly after the Trump administration came to power, quote, in 2017, ICE began a campaign of mass arrests of Cambodian nationals living under orders of supervision with the goal of compelling them to participate in repatriation interviews, end quote, and therefore facilitate their physical removal to Cambodia. At Mr. Kong's February 2018 appointment, he was required to fill out a questionnaire that he was told was for a travel document. Quote, it is undisputed, end quote, that he was not told that all of this might result in his detention and physical removal. But in March, ICE arrested him without notice on his way to work, giving him, quote, no explanation for his arrest until he had been detained for approximately 1 week, and that he was not told how to challenge his detention for about a month, end quote. He eventually filed a petition for habeas corpus in May 2018, just before Cambodia issued him those travel documents. Lucky for Mr. Kong, he was simultaneously able to reopen his deportation order approximately a week later, meaning just before boarding that plane possibly. There was no longer a final order of deportation to execute against Mr. Kong. My goodness. I'm getting anxious just reading this. And that meant that Mr. Kong was released and his habeas petition, a petition demanding his release, was dismissed. But Mr. Kong lived through a genocide, remember? He's seen it all. And it would appear he has no fear. In February 2019, he filed a claim for damages against DHS, quote, pursuant to the Federal Tort Claims Act, seeking compensation for harms caused by his arrest and detention, including lost wages and benefits. DHS acknowledged receipt of his claim, but did not otherwise respond to it, end quote. So he sued in federal court under the FTCA, quote, alleging false arrest, false imprisonment, and interference with a protected right, end quote, under Massachusetts law. Mr. Kong, the aptly named Mr. Kong. The district court, quote, confronted with the difficult issues in this case, granted the government's motion to dismiss for lack of subject matter jurisdiction, end quote. Specifically, as the U.S. government always argues, the district court agreed that INA Section 242G, quote, deprives the federal courts of jurisdiction over claims arising from decisions or actions to execute removal orders, end quote. And the court believed that that is what was at issue here. And so, Mr. Kong appealed. The First Circuit reversed the district court. Not true. INA Section 242G is a broadly worded statute. But also true, quote, the Supreme Court has cautioned against reading the provision to preclude jurisdiction over all claims related to removal, end quote. That's the seminal 1999 decision, Reno v. American Arab Anti-Discrimination Committee. Non-citizens can't sue to require that ICE place them in deferred action rather than execute a final order of removal. And non-citizens can't sue, I believe, to prevent ICE from filing a notice to appear, or from litigating removal proceedings. Among the 3 things that the jurisdiction stripping statute precludes are claims that arise from the decision to execute removal orders. And to the First Circuit, quote, in a but-for sense, Mr. Kong's claim of improper detention arose from the government's decision to execute his removal, end quote. Fine. But the but-for sense is not the standard to the First Circuit. Rather, to the court, what happened here is that, quote, the government re-detained Mr. Kong as it sought to arrange an interview with Cambodian officials with the eventual goal of removing him to Cambodia, end quote. Is that so connected to executing a removal order that Mr. Kong can't sue ICE for doing it? If assuming that ICE did something wrong in the process. That is a detention for an interview that might then result in physical removal. It is not so connected. Mr. Kong can sue. What ICE did was collateral to executing the deportation order. Mr. Kong wasn't attacking the deportation order itself, or ICE's decision to execute it. He was challenging ICE's decision to detain him, after releasing him 2 decades prior, just so they could ensure that he sat for an interview with a Cambodian official. ICE did not have any, quote, special justification, end quote, for doing so, such as, say, if Mr. Kong had repeatedly failed to comply with instructions in the past. This is important because, quote, continued detention is unconstitutional unless it serves these aims. And absent the right to judicial review through a habeas petition, the government could detain non-citizens indefinitely without needing to provide a justification to anyone, end quote. Horrific, said the First Circuit. Non-citizens are people too. Even now, as the current iteration of the Supreme Court seemed to recognize in Jennings v. Rodriguez a few years ago, there are a lot of activities that ICE can still be sued about, even if somehow tangentially connected to removal or detention. Just what ICE activities can result in a lawsuit remain unclear, but in Mr. Kong's case, suit was proper. This wasn't a brief detention, by the way, that might be accepted in certain circumstances. Mr. Kong was detained for over 50 days. 50 days where he began his day traveling to work, based on activities 25 years in the past, and without travel documents having been secured for his removal beforehand, allegedly, quote, without a valid warrant or any determination that his removal was likely in the reasonably foreseeable future, end quote. ICE might have had a warrant in the past, but that ship sailed a long time ago when ICE didn't deport Mr. Kong in the 90s. Quote, the connection between executing a removal order and detaining a non-citizen unravels if the non-citizen is not removed within that 90-day window, end quote. All of this reasoning and jurisdictional holding apparently aligns with decisions out of the 9th, 11th, and 3rd Circuits, at a minimum. The decision is of course very confusing and nuanced, and requires a read if you've got the guts of a Mr. Kong to bring such a challenge. But that was the gist, and quite the gist it is. Mr. Kong gets his claims heard by the district court. Whether he succeeds might all come down to whether in fact physical deportation was, at the time, quote, reasonably foreseeable, end quote. To reiterate, this is a civil FTCA action. Looks like it's all about money. Looks like regardless of what happens, Mr. Kong is sticking around, as it looks like he no longer has a final order of deportation. Congratulations Ethan R. Horowitz and the Northeast Justice Center, along with Adriana Lafael and Rebecca R. Krumholz, with the ACLU of Massachusetts. An hour of my life well spent. And that is Kong v. United States. Moving on to a duo from the 8th Circuit. First, Garcia-Pascual v. Garland, published by the 8th on March 14, 2023. This case is about non-LPR cancellation of removal and jurisdiction. Mr. Garcia-Pascual is from Mexico and entered the United States without authorization in 2005. 10 years and 3 weeks after doing so, DHS served him with a notice to appear. Lucky guy, because that means he just barely got the 10 years required to apply for non-LPR cancellation of removal under INA Section 240A(b). He could apply for that because he had a young U.S. citizen son named Saul. Mr. Garcia-Pascual had a partner in the U.S. as well, and said in his application that if he was removed, Saul wouldn't join him in Mexico. Later, Mr. Garcia-Pascual married his partner, who had her own U.S. citizen son, and whom Mr. Garcia-Pascual then additionally claimed as a qualifying relative for non-LPR cancellation of removal hardship purposes. But to succeed and at a minimum, Mr. Garcia-Pascual must show that if he is removed, at least one of his qualifying relatives will suffer exceptionally and extremely unusual hardship. Not an easy thing to do. Both children appeared to be doing well in school and didn't have medical issues. A blessing, but counterintuitively for non-LPR cancellation of removal, it can make establishing hardship that much more difficult. That being said, it seemed like the kids were doing fine because of Mr. Garcia-Pascual. His love and financial support was vital. So without it, so the argument goes, hardship. And the stepson actually only just learned that Mr. Garcia-Pascual wasn't his biological father, shocking enough. So separation now would be further difficult. DHS seemed to agree that Mr. Garcia-Pascual was a good guy. But DHS argued, and the IJ agreed, that he hadn't established the requisite hardship to meet the intentionally high burden placed upon non-citizens by Congress in the 1996 change of law. No longer is good character and long-term residence sufficient to stay in America. And so, quoting 25-year-old BIA precedent, the IJ held that, quote, separation from a family member does not constitute extreme hardship, end quote. Instead, it was the type of hardship that would, quote, normally be expected from the deportation of a non-citizen who has resided for a long period of time and has close family members in the United States, end quote. The BIA affirmed. Which means that before the Eighth Circuit, we have a no hardship finding in the non-LPR cancellation of removal context. Precisely the type of question over which circuit courts of appeals lack jurisdiction to review after Patel. Now true, the Eighth Circuit recognized that it retains jurisdiction to review constitutional claims, questions of law, and mixed questions of law and fact. And wouldn't the question of whether undisputed facts meet the legal definition of extreme and exceptionally unusual hardship be a mixed question of law and fact? Well, not after Patel, reasoned the Eighth Circuit. The Eighth Circuit thought that really, this is just an unreviewable argument that an immigration judge failed to give sufficient weight to a hardship factor. So too, the court believed that Mr. Garcia-Pascual's argument that the IJ and BIA properly failed to consider all harms in the aggregate, cumulatively, as BIA case law requires, was also not a mixed question of law and fact that it could review. Didn't really explain why that's not a reviewable question, but rather cited a pretty old case law from the Eighth Circuit that indicates it can't review the question. Concluding with an absolute post-Patel dagger, quote, a non-citizen's argument that the BIA applied the incorrect legal standard by failing to adequately consider certain factors is actually a challenge to the BIA's discretionary determination that we lack jurisdiction to review, end quote. The Patel hits keep coming. For what it's worth, Judge Arnold in concurrence appears equally hurt by that dagger, and while believing that Patel, in conjunction with prior Eighth Circuit precedent, requires this holding, quote, those precedents deserve another look, end quote. Judge Arnold believes that indeed, Mr. Garcia-Pascual has brought forth reviewable mixed questions of law and fact, and that the Eighth Circuit has been wrong in the past, and in some cases long before Patel, to hold otherwise. I've never seen the Eighth Circuit go en banc on the podcast, but there's always hope. Rally the troops, Judge Arnold. And that is Garcia-Pascual v. Garland. Next is USA v. Heard, published by the Eighth Circuit on March 16, 2023. Don't look now, but the Eighth Circuit is becoming the most friendly controlled substance offense circuit in the country. Another case with the Eighth Circuit affirming that overbroad isomers can make a drug's definition overbroad and therefore a conviction not a controlled substance offense. In the sentence enhancement context, of course. United States citizen Mr. Heard was convicted of being a felon in possession of a firearm. He has multiple prior offenses, including felony controlled substance convictions from 2011 for conduct committed in 2009. The Eighth Circuit doesn't even say what the statute or what the crime actually was, but it must be somewhat serious to be a controlled substance felony. Both convictions incorporated a Minnesota statute criminalizing the drug MDMA, also known as ecstasy. If those convictions match the definition of a serious drug offense under the Armed Career Criminal Act, Mr. Heard gets his firearm convictions enhanced by a lot of months. But the defense argued, and the district court judge agreed, that Mr. Heard's criminal sentence couldn't be enhanced on this basis because Minnesota's definition of MDMA was overbroad as compared to the federal definition of MDMA applicable at the time of conviction in 2011. For that reason, so the district court held, Mr. Heard's MDMA conviction was not a serious drug offense because the drug criminalized, MDMA, was not the same MDMA listed in the Federal Controlled Substance Act in 2011. Technical ruling with huge consequences. DOJ appealed. The Eighth Circuit affirmed the district court. As the Eighth Circuit has now similarly held in different contexts 4 times by my count. Quote, "The question for us is whether Minnesota's definition of MDMA sweeps more broadly than the one in the federal controlled substance schedules." End quote. That's it. That's the question. It's a matching of statutory drug definitions. MDMA, like some other chemical drugs, is composed of isomers. Don't ask me what they are. And when it comes to MDMA at least, quote, "Federal regulation expressly limits the term isomer to optical, positional, and geometric isomers. Those are the only MDMA isomers criminalized by the federal government." Minnesota, in contrast, until July 1st, 2011 at least, and like many states I believe, criminalized possession of more isomers. It's a bit confusing, but it seems like Minnesota also criminalized, quote, "isomers of the listed hallucinogens, including MDMA, without reference to the type of isomers penalized," end quote. So Minnesota didn't limit the isomers like the feds did. And, quote, "the common usage of the word isomer would include all isomers, regardless of the specific chemical structure," end quote. Again, unlike the feds, wasn't limited to merely optical, positional, and geometric isomers. What other isomers are there even? Beats me. But the 8th Circuit agreed that Minnesota's statute clearly criminalized more than the 3 listed in the Federal Controlled Substance Act. In a very clear sentence, the 8th Circuit states that, quote, "a drug statute that criminalizes even one additional isomer does not qualify as a serious drug felony," end quote. Oh my. Also, with the statutory text clearly overbroad, the realistic probability test has absolutely no role to play, said the court. Mr. Hurd may be going to jail, and he may have his conviction enhanced for other reasons, but it won't be because of MDMA. Before we move on, so by my count, and of course depending on the year of conviction, Missouri cocaine, Florida marijuana, Minnesota cocaine, and Minnesota MDMA are now out. And that's just in the 8th Circuit. Certainly more in the other circuits, and maybe even more in the 8th Circuit. And if you didn't catch it in how I was talking about all of this, dates and definitions are exceptionally important to these analyses. The applicable drug statutes to compare are the, quote, "statute at the time of conviction," end quote. Statutes change, and while the logic from this decision binds going forward, it may not apply to post-July 1st, 2011 convictions if Minnesota's definition of MDMA has changed to line up perfectly with the Federal Controlled Substance Act. Always need to do the analysis yourself, but here's your guide. You heard it here first. Only 8 pages to boot. And that is USA v. Hurd. And now, a word from our sponsors. This podcast is sponsored by Journey Business Plans. Journey is the leading business immigration plan writing company in the United States. 10 years. And they know immigration. Heck, they started as an E2 company themselves. Journey prides itself on its responsiveness and overall customer service, preparing business plans for E2, EB2 NIW, L1, EB5, and much more. If you don't yet know about Journey and don't want to listen to just me, ask your colleagues. Or even better, try them out. Visit www.journey.com and use promo code REVJOURNEY30 for a 30% discount on your first business plan. That's REVJOORNEY30. Or click on the link in the show notes. Two decisions, 8th Circuit. The 9th Circuit says, hold my beer. It's got 2 decisions as well. The first is Gutierrez-Alm v. Garland, published by the 9th on March 15th, 2023. This case is about the stop time rule. Mr. Gutierrez-Alm is from Nicaragua. He fled to the United States in 1989 at 8 years old, quote, 1 year after his father fled the country following his incarceration for taking up arms against the Sandinista regime, end quote. Due to similar concerns in Nicaragua today, the U.S. has instituted a program to parole sponsored Nicaraguans into the U.S. The more things change, the more they stay the same. Mr. Gutierrez-Alm, however, appeared not to have entered the U.S. lawfully, and I suppose at 11 years old was served with an order to show cause in 1993, the predecessor to a notice to appear. Immigration officials detained Mr. Gutierrez-Alm at the time, and, quote, he has remained entangled in deportation proceedings for 30 years, end quote. Gonna be a fun one. His first deportation hearing wasn't scheduled and didn't occur until 1996. By that time, he'd been living in the U.S. for over 7 years. That's important because, recall, Mr. Gutierrez-Alm was in deportation proceedings because they began before the 1997 change with IRIRA. At the time, there was no cancellation of removal. Instead, there was the more non-citizen-friendly suspension of deportation. Among many easier-to-establish elements, including hardship, suspension only required 7 years continuous residence rather than the 10 required of cancellation. But 1996 is a crazy year for immigration. Not only was IRIRA passed, but so was NACARA, which was, quote, enacted to ameliorate the effects of IRIRA for Central Americans who came to the United States because their lives and families had been torn apart by war and oppression, end quote. As relevant here, quote, NACARA authorized certain Nicaraguan immigrants who had entered the United States prior to 1995 to apply for lawful permanent resident status, end quote, even if they had entered without inspection or admission. And that's what Mr. Gutierrez-Alm requested in court, at this point in 1998. The IJ administratively closed his case so he could apply for NACARA before USCIS's predecessor, INS. But INS eventually denied, because by the time of adjudication in 2000, Mr. Gutierrez-Alm had apparently accrued a disqualifying criminal record. But still, nothing happened again for 7 years. In 2007, it appears, Mr. Gutierrez-Alm ended up in custody and recalendar deportation proceedings. But remember, these were still deportation proceedings, even though we're now 10 years into IRIRA. 5 years later, 2012 for those keeping track, Mr. Gutierrez-Alm applied for asylum and related relief in court. His father testified in support, describing his own story of political persecution and flight from Nicaragua in the 1980s. Maybe so. But it appears, understandably, that 8-year-old Mr. Gutierrez-Alm wasn't involved, and that the current government in Nicaragua has no interest in him. He also fears harm based on a belief that he'd be mistakenly viewed as a gang member in Nicaragua. The immigration judge denied asylum and related relief and protection. The IJ also denied Mr. Gutierrez-Alm's application for suspension of deportation. The IJ held that under the pre-IRIRA rules, service of an order to show cause, or OSC, and not service of a notice of hearing, stopped the accrual of continuous presence, meaning that Mr. Gutierrez-Alm's years stopped in 1993 when he was served with the OSC, rather than in 1996 when he received the notice of his hearing. Not such a debatable holding in 2012, but it is now, and it's what this case is mainly about. It went up and down to and from the Ninth Circuit for some other reasons, and once again, eventually made it back to the Ninth Circuit. Hence the many years. Finally, Issue 1. Does Mr. Gutierrez-Alm have the 7 years continuous presence such that he can apply for suspension of deportation? He's been here 34 years, of course, but if the OSC stopped the accrual, then as a matter of law, he's only got 4 years. It's a dispute, because in fact, the order to show cause did not have the time and place of his first deportation proceeding. As we now all know after Pereira and Chavez, such deficiencies, if contained in a notice to appear, would not implicate the stop time rule for non-LPR cancellation of removal. Same facts, but with an NTA and cancellation, Mr. Gutierrez-Alm would currently have 34 years continuous physical presence. But an OSC is not an NTA. Different letters. And the statute and regulations governing what must be in an order to show cause are not the same as those governing NTAs, relied upon so heavily by the Supreme Court in Pereira and Chavez. The BIA also kind of said so in a slightly different context recently in matter of JLL, episode 146, and other circuits have expressly differentiated OSCs from NTAs on this point. More complicated still, because it's actually the IRIRA stop time rule at issue. The same stop time rule that we discussed with non-LPR cancellation of removal. Even though it's an IRIRA rule, Congress made it retroactive to suspension of deportation cases, knowing that after IRIRA was passed, there'd still be some leftover suspension cases to decide. Congress didn't have to do that, but they did. That means that because of the IRIRA rules, a pre-IRIRA order to show cause stops the accrual of continuous physical presence for suspension of deportation. To repeat it though, because it gets confusing, that same IRIRA stop time rule isn't triggered by a deficient NTA because of how the INA defines the term notice to appear. So what about OSCs? Same stop time rule, same logic? No. To the Ninth Circuit, Pereira and Nis Chavez are NTA cases based on the legal definition of an NTA that requires the time and place of the first hearing in the NTA. By definition, to overuse the word in this decision, the definition of an order to show cause is different than the definition of an NTA. And quote, every circuit to address this question has held that Pereira does not apply to an OSC, a charging document issued before IRIRA under a separate statutory framework with distinct requirements, end quote. And that includes the Ninth Circuit in a previous decision in a slightly different context. Unlike the NTA definition, fatally, the statutory OSC definition instructs that, quote, immigration officials provide written notice of the time and place of deportation proceedings in the order to show cause or otherwise, end quote. That or otherwise language has unsurprisingly been interpreted to include a notice of hearing. Congress didn't write in that or otherwise release valve for NTAs, but they were there for OSCs. Ipso facto, an OSC remains an OSC even if it doesn't have the date and time of the first hearing, so long as, I guess, a notice of hearing is later sent. Which it was here. Meaning that the OSC stops the continuous physical presence. Meaning Mr. Gutierrez-Alm only has 4 years and is ineligible for suspension of deportation. That leaves only asylum, withholding of removal, and Convention Against Torture Protection. Apparently there's no dispute that the asylum application was filed untimely, so only withholding and CAT. Mr. Gutierrez-Alm first argued that, quote, he will face persecution in Nicaragua due to his father's opposition to the Sandinista government, end quote. And indeed, Daniel Ortega, the current head of the Nicaraguan government who the U.S. recognizes is persecuting political opponents, retook control in 2007 and was, at least at the time, part of the Sandinistas. It's complicated for sure, and I'm no expert, but there it is. Check out Flores Molina v. Garland, episode 112, for excellent non-citizen-friendly case law on all of that. Here to the ninth, though, it's been a long time. Mr. Gutierrez-Alm was a child when he fled, and nothing indicates that Mr. Gutierrez-Alm is like or will be perceived to be like his father. Plus, apparently, quote, the Nicaraguan government has since passed a law granting amnesty for political crimes that were committed in the 1980s, end quote. Nor to the Ninth Circuit did Mr. Gutierrez-Alm risk harm based on the potential that the Nicaraguan government would see him as a gang member if he was deported. The Ninth Circuit also went through and rejected all 4 of Mr. Gutierrez-Alm's proffered particular social groups, most notably holding that his particular social group of suspected gang members lacks social distinction as required of particular social groups. At least in this case. Looks like Mr. Gutierrez-Alm's brother is actually a gang member, and he was previously deported to Nicaragua. In some cases, the Ninth Circuit has recognized that, quote, persons who are not members of a gang, but who are incorrectly perceived to be gang members, may constitute a cognizable social group, in some circumstances, end quote. Vasquez-Rodriguez v. Garland, episode 67. Y'all taking notes? But in this case, there wasn't enough evidence to show that the group was distinct in Nicaragua. Plus, at the Ninth Circuit, Mr. Gutierrez-Alm's actual gang member brother was not harmed upon his own deportation to Nicaragua. The Ninth Circuit also denied CAT protection, meaning that Mr. Gutierrez-Alm lost his long case. One more thing. Some qualifiers on this holding in a footnote. If you've got an old order to show cause case, or a potential motion to reopen. The decision doesn't apply where an order to show cause has other statutorily prescribed deficiencies, or where there exists, quote, a defective notice of hearing, such as a notice that inaccurately details the location of an immigrant's hearing or provides an improper date and time, end quote. Interesting. A notice of hearing like that, I guess, could not perfect in order to show cause, thereby meaning that the OSC remains statutorily deficient. Never skip the footnotes. And that is Gutierrez-Alm v. Garland. Which brings us to Umana Escobar v. Garland, published by the Ninth Circuit on March 17th, 2023. This case is about a lot of things, including nexus. Mr. Umana Escobar is from El Salvador and entered the United States without authorization in 2012. Deemed to have a credible fear, he was placed in removal proceedings to bring his claim for asylum and related relief. As with so many notices to appear at the time, the NTA used to initiate those removal proceedings was deficient, as it lacked the date and time of his first hearing. A follow-up notice of hearing had that information, and he attended his removal proceedings through 2017. His asylum claims, quote, were based on the February 2009 murder of his father, the January 2011 attempted murder of his brother Carlos, and a threat against his family, which was made shortly after the attack on Carlos, end quote. His father was killed by gang members who police actually prosecuted and incarcerated. And it turns out that it was actually the town's mayor who ordered the killing of Mr. Umana Escobar's father due to a political fallout between the father and the mayor. 2 years later, gang members shot at his brother Carlos while he was on his way to work. Mr. Umana Escobar believes that the gang members were also targeting his mother, his nephew, and himself, thinking them in the car. Carlos was hospitalized, and during the stay, their mother received a death threat phone call. They, quote, wanted to kill us all, end quote, said the caller. Police were informed, but Mr. Umana Escobar fled without learning the result of an investigation, if one even happened. Carlos and his mother stayed behind. They live in hiding. An IJ deemed Mr. Umana Escobar credible. At some point, the decision is a bit unclear, Mr. Umana Escobar moved the immigration judge to terminate his removal proceedings because of the deficiencies in the NTA. He also alternatively moved the IJ to administratively close his case so he could file for an I-601A waiver. The regulations require admin closure to file such a waiver. Mr. Umana Escobar likely married a U.S. citizen during this whole process, and now may be eligible for an immigrant visa provided he gets the waiver. Decision doesn't say, but that's probably what happened. An IJ denied all relief, and the BIA affirmed. BIA also refused to terminate or administratively close his proceedings. After all, by that point, Attorney General Sessions had taken away administrative closure with matter of Castro Tum. No longer, though. More on that in a minute. The IJ and the BIA denied asylum and withholding based on a no-nexus finding. But it turns out the BIA didn't do so correctly, said the Ninth Circuit. True, the Ninth held that the IJ did apply the correct nexus standards. For asylum in the Ninth Circuit, an IJ must analyze whether the family membership, in this case, was one central reason for the persecution feared. But for withholding, an IJ must analyze whether a family membership or other protected ground is merely a reason. The Ninth Circuit rejected Mr. Umana Escobar's argument that the IJ had misapplied standards here. To the Ninth, the IJ properly conducted a one central reason analysis for asylum and the a reason analysis for withholding. But the Ninth Circuit agreed that the BIA messed up on appeal. Because when reviewing the IJ, the BIA, quote, should have reviewed the IJ's nexus determination de novo, not for clear error, end quote. Standards of review. See, long ago, the BIA held that an IJ's determination on nexus is a legal determination. That is, whether a non-citizen established that he or she will be persecuted on account of a protected ground is a legal conclusion, not a factual one. That's the BIA's 2008 decision in matter of SEG. And as every good appellate lawyer knows, appeals courts review legal determinations de novo, or in the first instance. And when you're challenging an IJ's decision, you always want to be in de novo land. While later BIA precedent explains that predictive findings, that is, quote, what may or may not occur in the future, end quote, are now deemed factual findings, as is, quote, what a persecutor's motive may be, end quote, the BIA still must, quote, review de novo whether a persecutor's motives meet the nexus legal standards, end quote. That is, whether it was one reason or one central reason, depending on the relief. Wonky AF. Watch out for landmines, BIA staff attorneys. And it didn't happen here. The BIA improperly reviewed everything relating to nexus for clear error. That's wrong, said the Ninth Circuit. It seems like the Ninth Circuit has some thoughts on the merits, too. Quote, in reviewing the IJ's nexus determination de novo, the BIA should now consider whether the IJ improperly disregarded Mr. Umana Escobar's testimony that his family members were in hiding, and whether considering that changes the likelihood that he would be persecuted if returned to El Salvador, end quote. All right. So it's remanded for that. The Ninth Circuit declined, however, to entertain Mr. Umana Escobar's deficient NTA arguments. Seems like Mr. Umana Escobar's BIA counsel argued that deficient NTAs invoke jurisdictional problems. But at the petition for review stage, Mr. Umana Escobar's counsel realized that the argument was dead in the water, and that the argument needed to now be brought as a violation of a mandatory claims processing rule. The Ninth Circuit held that Mr. Umana Escobar can't do that. He can't change his argument on petition for review, even though at base it was all still about the same deficient NTA. And even though, of course, the law is continuously evolving on this issue. But then, the Ninth Circuit also remanded for administrative closure. Oil actually recommended a remand for this matter because, of course, during the petition for review, again, evolving case law, Attorney General Garland issued matter of Cruz Valdez, meaning that the basis for denying administrative closure relied upon by the BIA, matter of Castro-Tum, was no longer good law. And that's particularly true in this case, as the underlying reason for admin closure was to file an I-601A waiver, which requires administrative closure by regulation. Ping-ponging back again, the Ninth Circuit affirmed the IJ and the BIA on denial of Convention Against Torture protection. But on the whole, a pretty good technical win. So it should be no surprise that congratulations are in order for Sabrina Damast and Jose Medrano for petitioner. I have it on good authority that Sabrina was preparing for this oral argument while at the same time, I believe, preparing for a very complicated panel that we were on together. Successful multitasking at the very highest of levels. And that is Umana Escobar v. Garland. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend, and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review, or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate for 5 credit hours, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all. And follow the show on Instagram and Facebook at Immigration Review, and send us a tweet at ImReview. That's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.